From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. The other moving part here on this issue of social media content regulation is the judiciary, and there are a bunch of different cases moving through the courts. But on Monday, the Supreme Court took one case. It has to do with Section 230, the liability shield that these internet companies rely on. But Alicia, this has to do with sort of a narrower issue of algorithms and what they recommend people. So this isn't really the blockbuster case, I think, that a lot of social media critics are hoping for. We're not quite there yet. But Alicia, can you explain what's going on in this case?
So this is a question of basically whether the companies can be held liable for, in this case, essentially contributing to, because their algorithms may magnify certain, maybe ISIS content, which is the allegation or the charge in this lawsuit, that they should be held liable for their algorithms. It's essentially a quote-unquote product liability lawsuit. It's an interesting argument because Section 230 doesn't explicitly protect these algorithms. If these platforms are involved in quote-unquote editing or developing content, they can still be held liable for these kinds of claims. So the question is, are these algorithms important to the editing, or are they essentially editing content or helping develop the content? And I think you could have an argument both ways. And even if the Supreme Court were to rule that they could be liable, there's a different question whether a jury would actually find them liable. So just because if Google or Facebook actually is, liable for the algorithms that they created, which I think will open up a Pandora's box and could probably force them to go to court a lot more to defend against their algorithmic actions. That doesn't necessarily mean at the end of the day that when they go to a trial that they will actually have to pay up billions of dollars. The other policy question, again, I have very mixed feelings about this issue. It's just going to be an invitation to the plaintiff lawyers to just go after these deep-pocketed companies, and it's very easy to find a claim to make these kinds of claims. And Section 230 kind of protects these companies to the point of why I feel so conflicted is I think sometimes they use 230 too much as a shield.
There's another case that is similar issue that is percolating about Snapchat, and at one point Snapchat had a filter where if you use the filter, it would show on the picture the speed you were going when the picture was taken. And there's a lawsuit percolating by somebody who was injured in a car crash, and apparently the driver was driving something like 100 miles an hour. And the argument here is that Snapchat knew that this filter was being used this way and, let it continue to exist on its platform before eventually pulling it down. That one I find a little bit stronger, that it's hard for me to see how that filter, that algorithm, whatever you want to call it, is covered by Section 230 liability protection. The Google one, Kim, I find a little bit more puzzling because Google's argument, I think, is that this is an editorial function. And if there were somebody whose job it was every day at YouTube to wake up and make a top 10 list of top 10 videos to watch on YouTube today, or whatever it is, top 10 new uploads, that looks to me like a pretty editorial job. And does it matter if it's a person doing it or if it's an algorithm that's doing it automatically? I don't know. I mean, that gets to the problem with these kinds of things, is that these social media sites are not really newspapers, they're not really bulletin boards, they're not really phone companies, and none of the applicable laws exactly fit them the way that you would want to make these easier cases.
Yeah, I mean, this is a problem, and hopefully the court, by taking this up, even though this particular case is looking at the question of algorithms, hopefully it is nonetheless an opening for the court to move on to those other questions about what does count as editorial function. One thing I find interesting about this case is it's around a situation in which the argument was that these algorithms were promoting ISIS recruiting videos. But I think some of the issues that are even more relevant are ones in which the algorithm or the human behind the algorithm are instead using those functions to overly censor free speech. A good example of this is Facebook CEO Mark Zuckerberg, acknowledged recently that in the days running up to the election that, yes, Facebook de-emphasized, as it was, or demoted stories about the Hunter Biden laptop. And we know that other of these platforms outright banned it, didn't allow it to circulate on their sites. That wasn't an algorithm doing anything. That's humans doing things. And in that case, is denying people crucial information, which gets to this question about whether or not some of these organizations should be handled as common carriers, the way that we treat, for instance, telephone companies, because if you are going to allow them to engage in any sort of viewpoint discrimination, they are fundamentally censoring basic information that's covered by the First Amendment. And I think the court's going to have to take up some of these really huge questions if it wants to get to a durable solution here, rather than a case-by-case basis that this particular case presents. They could go narrow, but I think ultimately down the road, courts are going to have to answer these great big questions.
Yeah, that is the Supreme Court appeal that is waiting in the wings, and we now have a split between the circuit appeals courts. There was a court that ruled against Florida's social media law and a court that ruled for Texas's social media law. And Alicia, you wrote about the latter opinion in Texas, a column titled "Big Tech Has No Constitutional Right to Censor." Can you give us a sense of your argument there?
So the Fifth Circuit, you have to be careful here because the Florida and Texas law do operate differently, and they do, and because of those, the constitutional questions are somewhat different. I mean, most concern the First Amendment, and the tech companies have both made a First Amendment argument against both laws. But in Texas's case, this basically banned or prohibited large platforms. So this would cover Twitter, Meta, YouTube, wouldn't cover Truth Social and some of the other smaller platforms with fewer users. It would ban these platforms from discriminating against users based on viewpoint or censoring them based on viewpoint. I mean, there were some other provisions that require kind of a disclosure about their censoring practices, but that was really the main gist of the law, was to prevent companies from these platforms basically deplatforming conservatives in particular for expressing, viewpoints that express skepticism of climate change, perhaps, or, COVID vaccines. So what the Fifth Circuit said is that based on the Supreme Court's precedents, Texas was seeking to regulate these platforms under common carrier laws. The nation has a long history of doing so, dating back to the founding and even before that, and then in England. And it is justified, or not necessarily justified, but it passes the smell test. Go back historically again to the days of the telegraph. States actually regulated telegraph companies under common carrier regulations, which prevented them from discriminating against speech or telegrams sent by, users, or in those days, it was journalist companies that they disliked or didn't have business relationships with. That was actually occurring all the way back then in the 1800s. And so states stepped in and tried to regulate this space. And that's essentially what they are doing now. It's very obviously constitutionally controversial because companies do have free speech rights, right? And the government cannot, based on precedent, cannot compel them to speak and cannot restrict them from speaking. What the Fifth Circuit, at least this panel, held is that, Texas's law doesn't do either. It basically just imposes, again, these common carrier regulations. And if these companies want to disavow the speech of users or these viewpoints that they dislike, they are free to do so. In fact, they can add fact checks to them if they want. So it doesn't actually directly implicate these corporations or these companies' free speech rights. It just regulates business conduct rather than speech per se.
I'm a little skeptical personally of this common carry argument because I think it creates some difficult line drawing problems. So the Texas law says that social media companies can't censor a user based on the viewpoint of the user or the viewpoint represented in the user's expression. And I understand, as Alicia lays out here, that their intent was to stop people who have dissenting views about climate change, for example, from being booted off of Facebook or Twitter. But I find myself wondering, what exactly is a viewpoint? Is it a viewpoint that jihadism is a glorious cause that will be rewarded in the afterlife? Or is it a viewpoint to be a Russian troll who is paid by Vladimir Putin to put propaganda out on social media sites? I don't know the answers to those questions. I have a hard time finding where a court or a government would be able to draw that line. And then also, what about sites that define themselves in opposition to something or with a specific community? If you start a social media site for pet owners or for Catholics or Protestants or whatever, and you have people on there that are saying things that go against your user base. I mean, it seems to me that these companies are, at bottom, they are media businesses. And what does it do to the advertising business of Twitter or Facebook if they're not allowed to take off the kind of stuff that their users find uncomfortable and outrageous, as Elon Musk suggested in the clip we played of him at the top? So, Kim, it will be fascinating to watch the courts, and eventually, I agree, the Supreme Court is going to get in here. It'll be fascinating to watch them wrestle with these questions, but we'll give you the last word, Kim.
Well, one thing that I would note, though, is that, for instance, if you look at the Texas law, it doesn't cover speech that isn't protected by the First Amendment, meaning these big companies still have the right to take things down that are, again, unprotected speech. For instance, yelling fire in a crowded theater. We have had many court cases over the years that explain what is protected speech and what isn't. I'd argue that most of the examples that you just gave are protected First Amendment speech, not all of them, but most of them. The Communications Decency Act also spells out certain speech that is not necessarily protected, speech that's obscene or lewd, filthy, excessively violent, or harassing. But that's very different than climate, for instance. And so my problem is right now, they want to have it both ways. They want to suggest that they're simply, a platform. They're not legally liable for anything that anyone puts on there because it's all third-party stuff, but they're taking actions, in fact, to curate and completely decide what everybody can see, which is an editorial function, which should make them legally liable in some way. So I do think that there's a way to get to an ending here. I'm not as concerned about the common carrier title because we do use it, and these platforms have become so important to getting stories out and information out that it's now hard to suggest that, well, they're just private companies, let them do whatever they want, because there are some real threats to free speech in that regard. So I'm thrilled to see the courts taking it up, and I'm particularly interested to see where this Texas and Florida law land.
Thank you, Kim and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we will be back tomorrow with another edition of Potomac Watch.